Hello and welcome to Byjus Exam Prep IAS. Before we start with our today's analysis, we have an announcement. Byjus Exam Prep IAS would be conducting the National Scholarship Test, which is scheduled to be conducted on 20th of November at 11 a.m. What is that you have to do? Link will be given in the description box. Give the necessary information and you would be able to win some attractive scholarships. Let's get started and look into the first article. The first article says this unseating of vice chancellors is faulty. Let us try and understand what is this article all about. We have the Supreme Court of India which has delivered two judgments with respect to the appointment procedure of the vice chancellors. We have the vice chancellors who are appointed by respective governments of Gujarat as well as Kerala. The Supreme Court looked into this particular case and has declared that procedures were not followed by the state governments, and at the same time they were also in violation of the UGC norms, and ultimately said that this particular appointment is not right according to the laws established and the rules framed by the UGC. Let us try and understand what are these two judgments. First, let us take a look at what happened in the state of Gujarat. Gambhirdan K. Gadvi versus the state of Gujarat. From Sardar Patel University, Gujarat, the court quashed the appointment of the incumbent vice chancellor on the ground that the search committee did not form a panel for the appointment of the vice chancellor and therefore was not in accordance with the UGC regulations of 2018. Now the question is, you have the UGC, which happens to be the University Grants Commission. It has come up with the regulations of 2018. What did the Supreme Court say? The Supreme Court said as per the UGC, there were certain rules and regulations that had to be followed by the state government of Gujarat. But contrary to these regulations, they have not set up a panel which was supposed to have been established. So as a result, whatever appointment has been made by the state government with respect to the vice chancellor is not right, said the Supreme Court of India when it comes to the Gujarat. Then there is another case with respect to Kerala as well. Professor Srijit PS versus Rajashree MS. With the bench of justices, the appointment of the Vice Chancellor of the APJ Abdul Kalam Technological University Thiruvananthapuram was challenged on the ground that the search committee recommended only one name, which is against the UGC regulations. What is the UGC regulation? Whenever a VC has to be appointed by the governor should be given many names. Let's say, for example, first person, second person, third person, fourth person, so on and so forth. From the series of names that are given to the governor will select one person finally on the basis of merit, on the basis of criteria, and this person shall be appointed as the vice chancellor for a relevant university. But in the state of Kerala, what exactly happens? The governor was not given the series of names. Instead, only one name was suggested. So according to the Supreme Court of India, this is a violation of the UGC. The UGC had suggested that the governor should be provided multiple names, but then this was not provided to the governor. Only one name was provided. So the Supreme Court went on to say that this particular proposal made by the state government and the appointment of the vice chancellor to one of the universities is not right and is in conflict with the UGC regulations, and as a result, such a person should not be appointed as the vice chancellor of one of the universities in Kerala. The Supreme Court, while coming up with this entire judgment, looked into one of the important articles of the Indian Constitution, which is Article 254 of the Indian Constitution. What does the article say? A VC is appointed by the Chancellor under the relevant University Act, but the Supreme Court has brought in Article 254 of the Constitution to rule if provisions of the state law are repugnant to the provisions of the Union law, the state law will become void. This is where we have to look at Article 254 of the Indian Constitution. What does it say? Inconsistency between laws made by Parliament and laws made by the legislature of the states. How does it work? Let's say, for example, we have a central law, a law which is passed by the Parliament of the country. Then we have a state law passed by the state legislature. Let's say we have one of the entry items in the concurrent list. In the present situation, it happens to be education. So who can pass the laws with respect to education? Central government would be able to place the laws. State government would be able to make the laws as well. But if there is a law that is already drafted by the Parliament, parliament and it is also in place, there is also a state law, but this state law is in conflict with the central law. In that case, what would happen? It is the central law which will prevail, and those parts or that particular law or that particular provision which is in conflict with the central law will be completely eliminated, or it will only be the central law which will prevail over the state government's law. Added to it, the article also goes on to say that there is a central law. There is also a state law as well. This state law is sent to the president for reference, and the president has given the assent as well. In this case, the state law may prevail as well. So this article currently goes on to say that when you consider the state law and the central law, what has the Supreme Court taken into consideration? It has said that the state government's law, that is the Universities Act of the state government, is in conflict with the UGC law, which according to the Supreme Court is the central law. This is how the Supreme Court has come up with a judgment saying that the state universities laws are in violation with the UGC regulations, and ultimately it is the central law which prevails over the state law. So the Supreme Court made use of the interpretation of the 254, where it said that we have the State Universities Act. This State Universities Act should have complied by the UGC regulations. Since it is not complying by the UGC regulations, the central law will prevail because this part of the state law is in conflict with the central law. So ultimately it is the central law will prevail, and as a result, whatever appointment of the vice chancellors has been made is not right, says the Supreme Court of India. However, the author is saying that this is not the right interpretation. Why? That is because first, the author goes on to say a careful reading of Article 254 would show that the repugnancy under this article relates to a state law and a substantive law made by the parliament. It implicitly excludes rules and regulations. What does this mean? When you look into this article, it is under the UGC regulations. What do we understand by this? We have something called as the delegated legislation. What is this delegated legislation? We have the legislature, we also have the executive. Who makes the laws? It is the legislature. Who implements the laws? It is the executive. The core skeletal structure of a law is given by the parliament, which happens to be the basic fundamental mother law. Then the executive may put in some muzzle to the law, to the skeletal structure, which is called as the rules. So it is only the law, that is what is drafted by the legislature, that has to be taken into consideration, and not the rules drafted by the executive. So the author, as the first interpretation, goes on to say, if it is a law and a conflict exists between the central government and the state government, yes, central government law will prevail. But what is happening in the present situation? The present situation, it is the UGC rules, it is the UGC regulations. UGC regulations are executive in nature, so it is not a law, but it is a rule. Since 254 speaks about law and not about rules and regulations, it is violating this very core principle, says the author. Let me reiterate this example for you. What is a law? It is something which is passed by the parliament. What is a law? A law is something which is passed by the state legislature. So if there is a law of the state legislature which is in conflict with the central government's law, which is drafted by the parliament, in that case, whatever has been passed by the central government, the same will prevail. But in the present situation, you have the mother law which is already there. Then you have the UGC, but UGC is coming up with not a law but rules and regulations. So if it is conflict of laws, then it is good. That is when central government's law will prevail. But in this case, it is the rules that have been drafted by the UGC. In this case, there is no clash, and ultimately the State Government's University Act should have prevailed, says the author. Second, the rules and regulations made by the subordinate authority, though laid in parliament, do not go through the same process as law. As I initially explained you, we have something called as the delegated legislation. When it comes to the parliament, a law is passed in the parliament. It goes through its own process of scrutiny. Sometimes it is appointed or given to a committee. The committee will also look into it. Sometimes an expert committee outside the parliament will also be appointed. Let's say, for example, we have the Sri Krishna committee. authority to look into data privacy laws, so on and so forth. So what you will have is the rigorous reading of the law. But when it comes to the rules, these rules are made by the executive. The scrutiny that is required may not have been gone through as well. In that particular case, how can you compare a central rule or one of the subordinate bodies has drafted this rule? How can you compare this rule passed by the UGC to the law passed by the state government? So the state government will also have its own scrutiny committee. It will have its own share of experts. It is also the will of the people represented by the representatives of the state. So if they have drafted a law, on the other side there is a rule, in that case if there is a conflict, the state government's law should prevail, because these are the representatives passed by the legislature and not the rules. So if there is a conflict between the state government laws and the rules drafted by a subordinate body like UGC, then in that case the state government's laws should prevail, is the second argument given by the author. Third, the constitution does not in general terms define the term law. So when you look into article 13 of the Indian constitution, it basically speaks about law. So the author goes on to say, under this particular article, it does not speak about rules, regulations, so on and so forth. If it is law, only then it matters. The rules, the regulations, the delegated legislations should not have any issue. If there is anything, then it is only the state law which will prevail over the rules in this case, says the author. Fourth, the regulations made by a subordinate authority of the union overriding a law made by the state legislature will amount to a violation of federal principles and a negation of the concurrent legislative power granted to the state by the constitution. What does this mean? This means in a subordinate authority, you have very few people. These people are drafting the rules and regulations. It is not the will of the people. And whenever there is a skeletal structure that is already defined by the legislature, whatever the UGC drafts or whatever any authority should draft in the near future, it shall be within the contours of this delegated legislation. They cannot write or make a law which is in conflicting with the original law. So the rules are drafted by the subordinate body, and this subordinate body is not given such powers as well. It should be within the skeletal structure of the law. In this case, you have the Universities Act, which is passed by the state, which is the will of the people. The legislatures are passing it. It is a subordinate body. Only few people are present in this case. So a conflict basically means what should prevail is the State Universities Act, and the Supreme Court may be wrong according to the author. Finally, the UGC regulations on the appointment of VCs are outside the scope of the main provisions of the UGC Act, as none of its provisions refers to the appointment of VCs. As I told you, we have something called as the mother law, which is the legislative part designed by the legislature. Whatever rules have to be framed, it has to be only done within the contours of this particular law. If there is a violation, then such rule can be immediately be deleted. When the mother law does not give the UGC to make any of the procedural action plan with respect to the VCs, how can the UGC come up with it, is another argument made by the author. So the Supreme Court held in Satyapal Reddy versus Government of AP that the court has to make every attempt to reconcile the provisions of apparently conflicting laws, and the court would endeavor to give harmonious construction. The proper test would be whether effect can be given to the provisions of both the laws or whether both the laws can stand together. So looking at all these arguments, the author goes on to say that this Supreme Court judgment with respect to the appointment of VCs may not be right according to the author. So the author goes on to say that in case rules are present, laws of the state are present, the precedence should be given to the law of the state because it is the will of the people. But when it comes to the rules, it is only a subordinate body which is doing it, and if it is a clash between rules, regulations and state law, the state law should prevail. Why? Because Article 254 of the Indian Constitution only speaks about clash between laws and not between a law and a rule book, is what is this article all about. It is this that we have to understand with respect to this article. Now let's look into the next article. This article says quest for transparency in FTA negotiations. Let us try and understand what is this article all about. Before we discuss this article, let me give you one of the informations which can also be important from the mains examination point of view. We have something called as the spaghetti bowl effect. What is this spaghetti bowl effect? There are multiple countries world over. Let's say for example, we have India. What does India do? India enters into a free trade agreement, let's say hypothetically with Bangladesh. India enters into a free trade agreement, let's say with Nepal. India enters into a free trade agreement, let's say with Japan. India enters into a free trade agreement, let's say with South Korea. So what has India done? India is not engaging on the multilateral front, but it wants to seek benefits from one particular country or number of countries. So it directly enters into a free trade agreement with all these countries on a bilateral platform. When it enters into the free trade agreement with all these countries, one of the questions that always comes into picture is what is called as the rules of the origin. What is this rules of the origin? Let's say for example, we are importing something from Bangladesh. Let's say we are importing clothes, or let's say for example, we are importing gadgets from Bangladesh. So whenever an export is made from Bangladesh to India, it has to be produced in this particular country. It has to be manufactured in this particular country, which means that this particular product's origin should be in Bangladesh. This should also mean that if another country, let's say for example, we have China. What is China good at? China is good at export market. If there is a particular product from China which has been manufactured in China, it is sent to Bangladesh. Now this product is sent to India. That is not right according to the free trade agreement. So this is where the spaghetti bowl effect comes into picture. What does it say? It says that any country for that matter would have entered into free trade agreements with multiple countries. When you enter into free trade agreements with multiple countries, let's say India is entering with Bangladesh, Japan, South Korea, all these countries. So China may have exported some product, or any country may have exported a certain product to another country. Now this country would also export this product to India. How are we going to understand this rules of origin, or where is this particular product manufactured from? What if they change the cover? What if they change the basic things as well? In that case, how are we going to ensure that there is the rules of origin framework that is followed? So spaghetti bowl effect basically goes on to say, too many free trade agreements, then it means that there is a lot of confusion and dilemma. This is basically leading to a lot of labyrinth like situations, and ultimately the free trade effect or the free trade agreements impact may not be successful. Is what is this spaghetti bowl effect? So this is in reference to the free trade agreement. The term was first used by Jagadish Bhagawati in 1995 in the paper US Trade Policy, The Infatuation with Free Trade Agreements, where he openly criticized free trade agreements as being paradoxically counterproductive in promoting freer and more open global trade. According to Bhagawati, too many crisscrossing FTAs would allow countries to adopt discriminatory trade practices and reduce the economic benefits of trade. This was also put up on our Telegram channel as part of the topic of the day. So please do join our Telegram channel if you have not yet joined it. Now let's understand what is this free trade agreement that we are speaking about with respect to India and United Kingdom. India and United Kingdom for a very long time now have been trying to engage and get in terms with the free trade agreement. But then this article primarily focuses on some of the issues that are existing in India. There are some mechanisms which are present in United Kingdom. There is institutional check when it comes to free trade agreements in United Kingdom. Mechanisms have been established, but that is not present in India. So India can take a leaf out of United Kingdom, learn a lesson from United Kingdom, and ultimately progressively implement the same when it comes to India. Is what is this article all about? Let us take some of the examples given by the author. The author says, first, there is something called as the Department of International Trade in United Kingdom. It publishes a policy paper laying down the strategic objectives behind negotiating and free trade agreement and why it is important for UK to have an FTA with a particular country. So there is something called as the Department of International Trade in the United Kingdom. What does it do? It basically enters into a study. This study will try to understand why United Kingdom has to enter into a free trade with India, why United Kingdom has to enter into a free trade with, let's say, China, or why should United Kingdom enter into a free trade with United States of America, and ultimately it will present a policy paper. So it will understand the pros and cons of it, what are the various impediments that are existing, why United Kingdom should enter into a free trade agreement, what is the advantage for United Kingdom. All this will be understood, and ultimately a policy paper will also be published as well. Do we have a parallel in India? No. In India, the author goes on to say no such policy paper, no such document is produced publicly. So when it comes to United Kingdom, everything happens on a transparent basis, but in India, we do not have such impact study that is conducted. We have the Commerce Ministry, which happens to be the nodal body dealing with the FTAs on its website, but then it does not provide any kinds of FTA related negotiations, and we do not have such policy paper is the first drawback with respect to India. This is an advantage when it comes to United Kingdom because they have a mechanism, they have an institutional structure, they also engage in research, but this is not in India. So India should follow it and should take a leaf out of United Kingdom's process is the first recommendation given by the author. The second, the policy paper that the DFIT publishes also contains the inputs and responses received by various stakeholders such as businesses, non-governmental organizations and others. As I told you, they would come up with what is called as the policy paper. This policy paper will do a rigorous research as well. Let's say, for example, they are speaking about the manufacturing. Who are involved in the manufacturing? It is the manufacturing companies. Or let's say we are speaking about the service industry. Let's say IT as one of the examples. So who are the people involved? Let's say there is a company A, there is a company B as well. Or let's say, for example, if it is something to do with impact on a social front as well, because there is a particular company that is coming in, this may emit a lot of carbon emissions as well, or it will also have an impact on the environment. So taking the viewpoints of the NGOs, whether it will have an impact on the environment, what could be the likely consequences, all of it is taken by this particular policy research paper. Their viewpoints are also considered, the business viewpoint is considered, the government ultimately discusses all it because it has a research paper right in front of it, and they decide whether the free trade agreement's objectives have to be taken forward or not. But in this particular case, we do not have any such policy papers, or there is no such recommendations that are heard by different stakeholders. Is another major problem in India. On one side, we have it in United Kingdom because of this policy paper presented by the Department of International Trade, but that is not same in India. So the policy paper explains the government views and specific suggestions would be taken in United Kingdom, but the Commerce Ministry also takes stakeholder consultations. It also has interministerial meetings, but then there is no public record of these discussions, whether it has been accepted and implemented or not. How do we know about it? So this is not transparent, and it has to be made transparent is the second recommendation. Third, in the United Kingdom, the strategic objectives identified by the government for signing an FTA are scrutinized by the UK Parliament. This job is performed by the International Agreements Committee of the British Parliament. So we have the legislature and the executive. Yes, it is the prerogative of the executive to basically enter into an agreement and ultimately do something good for the country. This is the principle that is followed in UK as well as in India. There is questions that can be asked by the legislature, the UK Parliament, to the executive, but there is no such flow when it comes to the Parliament in India. Yes, we have the legislature to question them, but at the same time there is no institutional framework. This job is performed by the International Agreements Committee of the British Parliament, and it gives all kinds of witnesses, examines the government's strategic objective of signing this particular FTA. The UK government responds to all these recommendations. But in India, there is no mechanism for such parliamentary scrutiny of the executive's actions during the free trade agreement negotiation is the third concern voiced by the author. Fourth, in the United Kingdom, under the Constitutional Reform and Governance Act of 2010, the executive has to lay down a treaty before the British Parliament for 21 sitting days with an explanatory memorandum before ratifying it. But in India, there is no such avenue because when it comes to United Kingdom, it allows the Parliament to know what the executive is up to, what is this treaty up to. But in India, there is no mechanism for any role of the Parliament in the ratification of treaties, including the free trade agreements. So this article currently goes on to say that India should learn a lot of lessons from the United Kingdom model for the free trade agreements. It goes on to say the executive should make a clear economic case outlining its strategic objectives, and the executive should be under an obligation to consult all the stakeholders. The Indian Parliament should also constitute a committee similar to that of the International Agreements Committee, and at the same time, the executive should also place the free trade agreement on the floor of the Parliament for a certain duration, allowing the Parliament to debate as well. These are some of the recommendations that have been given by the author when it comes to the free trade agreements that has to be followed going forward. It is this that we have to understand with respect to this article. Now let's look into the next article. This article says carbon border tax. Let us try and understand what is this article all about. This article says the European Union has proposed a policy called as the carbon border adjustment mechanism to tax products such as cement and steel which are extremely carbon intensive with effect from 2026. We have to understand what is the meaning of this carbon border tax. Let's assume for a moment there is one of the industries in India. This industry happens to be the cement industry, or let's say for example there is a steel industry as well. This steel industry and the cement industry emit a lot of carbon. So this basically means that there are a lot of carbon emissions that is happening from these industries. One happens to be the cement industry, the other happens to be the steel industry, or any industry for that matter, where a large scale carbon emissions have been happening with respect to these industries. So what is the European Union proposing? If there is a particular country which is making an export, let's say we have the cement product from India or steel products from India, it is being exported to the European Union. In that case, what they will impose is a tariff because the ultimate product is come from the environmental consequences, which means to say there is carbon emissions from these industries, so a certain taxes will be imposed if it has what is called as the carbon emissions. So basically any industry, we have taken the example of cement and the steel industry, so it can be any industry. So if it has emitted carbon emissions, it has emitted greenhouse gases, and a suitable amount of damage control is not done by that particular industry. If a country exports this product to European Union, in that case tariff will be imposed on such products. Is what is this carbon border tax? Since a product is being exported from one border to another, since there is emission of the carbon, they would be imposing the taxes is this carbon border tax. This has been opposed by the basic countries which include Brazil, India, South Africa and China. What have these countries said? These countries have now gone on to say that this is a protectionist stance taken by the European Union. They are shielding their local industries, they are preventing the foreign competition, and this is what they term as green protectionism. And this could ultimately lose the trust deficit between India, China, Brazil, South Africa, these countries with the European Union, and ultimately European Union may also have reverse actions decisions by these countries as well. So in case these countries so decide, they can also retaliate as well. If there are products that are coming from the European Union, they may also impose the taxes as well. Countries could also decide to impose barriers on the EU imports. In response to it, they can also adapt their own tariff and non-tariff barriers as well. So ultimately what it will lead to is lot of clashes, friction between these countries and the European Union. So the European Union will have to consider before making such decisions is what is this article all about. For understanding more on this, what we will come up with is a explain session about COP27. You can look into it to understand in detail. Now let's look into the next article. This article says India takes part in Moscow talks on forming inclusive government in Afghanistan. Let us try and understand what is this article all about. What is the Moscow talks? The Moscow talks is one of the several platforms on Afghanistan which began even before the Taliban takeover of the Kabul, consists of Russia, China, Pakistan, Iran, Kazakhstan, Tajikistan, Kyrgyzstan, Uzbekistan, Turkmenistan and India. What is this all about? This meeting will have participants who will discuss about the Afghanistan humanitarian situation, ongoing efforts about various stakeholders to provide assistance, intra-Afghan talks, formation of an inclusive and representative government, efforts to counter threats of terrorism and ensuring regional security. So the Moscow talks is where all these countries come together and they discuss about the future of Afghanistan. As of now, human rights are violated, women rights are violated. Within the country, the power has been captured by the Taliban. Many people are not considered in the government. It is not inclusive as well. Women are not part of the political system. Certain tribes are not part of the political system. The government which was previously present is not even taken into consideration by the Taliban. These are the issues. Added to it, from Afghanistan, what could be the issues, the spillover efforts? Let's say, for example, terrorists from Afghanistan may have clashed with some other country. This can also lead to terrorist related activities as well. Then there is drug issue in Afghanistan. All this will be discussed and ultimately a desired outcome will be discussed to design the future course of Afghanistan with all these countries. So the Moscow talks are nothing but all these countries coming together and discussing about the future objectives for Afghanistan. It is this that we have to understand with respect to this article. Now let's look into the main practice questions. The Supreme Court's conclusion that the provisions of the State University Act are repugnant to the regulations of the Universities Grant Commission under Article 254 is faulty. Examine. In India, there is no mechanism for any role of Parliament in the ratification of free trade agreements. Explain. So please write all your answers on the comment section, peer review, and do give feedback to your friends' answers. So this is it for today. Thank you for watching. All the best.